Hello, my name is Maurice Nivera and I am a third year accounting student at Pass College. Today I'll be talking about business tax, in particular, transfer and business taxation with special topics. And also, the Chapter 1 succession and transfer taxes under the transfer and business taxation with special topics. The modalities and methods of obtaining and other real properties rights are quite complicated. There are several methods to acquire, transfer, and lose ownership. Under the new Civil Code, Article 712, ownership may be acquired through occupation, intellectual creation, law, donation, tradition, contract, prescription, and succession. Transfer taxes. These are the taxes imposed upon the gracious disposition of private properties or rights. A transfer tax is a fee paid on the transfer of property ownership or title from one individual or business to another. A state, county, or municipality may levy a transfer tax. It is often not deductible from federal or state income taxes, but it may be added to the cost basis for calculating profit on the sale of securities and investment property. Some states regard transfer tax to be an excise tax. Onerous transfer. This is the opposite of gratuitous, subject to business taxes instead of transfer taxes. This is where the transferee gives consideration in return for the property or rights received. Donation mortis causa. This is when the transfer takes effect at the time of the death of the owner. A gift made by a person to the donor in contemplation of impending death, also known as a deathbed gift. It is when the donor dies, the subject matter of the gift does not pass to the personal representative but to the person the deceased intended to benefit, which is the donee. Donation inter vivos. This is the transfer that takes effect during the lifetime of both donor and donee. This is when the deed of donation provides that the donor will not dispose or take away the property donated, thus making the donation irrevocable. He, in effect, is making a donation inter vivos. He parts away with his naked title but maintains beneficial ownership while he lives. Moving on to succession. This is a mode of acquisition by virtue of which the property rights and obligations to the extent of the value of the inheritance of a person are transmitted through his death to another or others either by his will or by operation of law under the Article 774 of the new Civil Code. One thing to note here is the amount of obligation acquired or inherited by an heir should not be more than the combined value of the properties and rights inherited, liabilities up to the properties, rights inherited. Nature. Next is nature of transfer taxes. What is it? Subject matter. Privilege of the transferor to gratuitously transfer property or rights, which takes effect at the date of death of the transferor or during lifetime of the donor and donee, shall be classified as excise tax or privilege tax. The law that governs the imposition of estate tax. First is the estate taxation. This is governed by the statute in force at the time of death of the decedent. Next is the estate tax. Accrues as the date of death of the decedent, and the accrual of the tax is distinct from the obligation to pay the same. It is well established norm that estate taxes is determined by the legislation in effect at the time of the decedent's death. The estate tax accrues as of the decedent's death, and the accrual is different from the responsibility to pay the tax. When the deceased dies, succession occurs, and the state's authority to tax the privilege of transmitting the inheritance vest instantaneously. As a result, the tax rates and procedures outlined in these regulations will apply to the estate of a decedent who died on or after the train law's effective date. There are kinds of succession. One is the testamentary or testate, legal or intestate, and mixed succession. Testamentary or testate, this is the result from the designation of an heir made in a will executed in the form of prescribed by law. While legal or intestate, effected by operations of law, since the decedent did not execute a will or if the last will and testament executed by him is void. An inheritance is intestate when 1. A person dies without a will or with an invalid will or one which has subsequently lost its validity. 2. When the will does not institute an heir to or dispose of all the property of the testator. In this case, legal succession shall take place only with respect to the property not disposed. 3. If condition for an heir does not happen or is not fulfilled, or if the heir dies before the testator or repudiates the inheritance without a substitute stepping into the heir's place. And lastly, when the heir is disqualified from inheriting. Last is the mixed succession, effected partly by will and partly by operation of law. Inheritance is mixed if only part of the property has been disposed of in a will. In this case, the rules of legal or intestate succession shall be applied with regard to those properties not disposed of. There are also elements of succession. One is decedent. This is the general term applied to the person whose property is transmitted to succession, whether or not he left a will. If he left a will, he is called a testator. An executor is a person designated in the last will and testament to carry out the provisions of the decedent's will. Administrator is a person appointed by the court and performs the same duty in lieu of an executor If the latter refused to accept appointment, failed to qualify under the law or the last will, and testament did not appoint one. Number 2, inheritance estates. Inheritance or estate include all the property rights and obligations of a person which are not extinguished by death and always shall accrue thereto since the opening of succession. Rights which are purely personal are not transmittable, for they are extinguished by death. Under the article of the New Civil Code, under the Article 776 New Civil Code. Last, successors. This is the person who is called the succession either by the provisions of a will or by operations of law under the Article 782 New Civil Code. Devices and legatees are persons to whom gifts of real and personal property are respectively given by virtue of a will. Successions or heirs are classified under the law as follows. First, compulsory heirs. Those who succeed by force of law to some portions of the inheritance in an amount predetermined by law known as the legatime. They succeed whether the testator likes it or not. They cannot be deprived by the testator of their legatime except by this inheritance properly effected. There are kinds of compulsory heirs. First is the primary. Have precedence over and exclude other compulsory heirs, legitimate children, and descendants. Second, secondary. Succeeds only in the absence of the primary compulsory heirs, legitimate parents, and ascendants. Last is the concurring. Succeed together with the primary or secondary compulsory heirs. These are the illegitimate children and descendants and surviving spouse. Second, to to the kinds of successions or heirs are the voluntary heirs, instituted by the testator in his will to succeed to the inheritance of the portion thereof of which the testator can freely dispose. Free portion refers to the portion or value left in the estate after deducting the legitimes of the compulsory heirs determined through the last will and testament. Last is the legal or intestate heirs, succeed to the estate of the decedent by operation of law. Decedent died without valid will or his estate was not entirely disposed of by will. See, this is the composition of ghost estates. You can see the decedent's estate. There is legitime, which is legitime is a part of the testator's property which she cannot dispose of because the law has reserved it for certain years, who are therefore called compulsory heirs under the Article 886 Civil Code. They own 75% of the estate, and the legitime is to be inherited by the compulsory heirs, which the portion of the estate is reserved by law specifically to the compulsory heirs, regardless of whether or not the last will and testament was prepared. And free portion also owns, for example, also owns the 75% of the estate. This is the portion of the estate which the testator can freely dispose of. Hence, anyone may inherit from free portion. Nonetheless, voluntary heirs may inherit only if mentioned in the will. And to be inherited by, these are the free portion can be inherited by compulsory heirs or voluntary heirs. As we write in the last will testament, in the absence of a will, this portion of this estate shall be distributed to intestate heirs. Now, order of priority for succession. First, legitimate children or descendants. Second, legitimate parents or ascendants. 3, illegitimate children or descendants. 4, the surviving spouse. 5, brothers and sisters, nephews and nieces. 6, other collateral relatives within the 5th degree. And last, the state. Why is there a need for an order of priority for succession? You may ask. An established order of succession is a normal way of passing on hereditary positions and also provides immediate continuity after an unexpected vacancy in cases where office holders are chosen by election. The office does not have to remain vacant until a successor is elected. Next, collateral relatives. Sorry for the pronunciation. Consanguinity or blood relatives. These are the relations of persons descending from the same stock or common ancestors. These are known as the blood relatives and are said to be related by blood or consanguinity. There are types of collateral relatives. First is the lineal, subsists between persons of whom one is descendant in a direct line from the other. Collateral subsists between persons who have the same ancestors but who not descend or ascend from one another. Affinity, connection existing in consequence of a marriage between each of the married spouse and the kindred of the other. Wills. For example, I will provide for you a illustration how the inheritance is distributed, or how the cut this please. One illustration is when the deceased has children and a surviving legal spouse. With a will, with a will you will have one legitimate child or his children, or the children of the the deceased, or he will get half of the estate, while the surviving legal spouse 1/4 of the estate, and the free portion 1/4 of the estate. For example, if the estate is 1 million, then the legitimate child receives 500,000, and the surviving legal spouse receives 250,000. The rest is given to whomever the estate owner wishes, as stated in the will. Without a will, one legitimate child will only be given half of the estate, and the surviving legal spouse will be given half of the estate. For example, the estate is 1 million. Then the legitimate child receives 500,000, and the surviving legal spouse receives 500,000 also. Another example is this: surviving legal spouse and one legitimate child or his children and one illegitimate child. With a will, legitimate child gets half of the estate. A legitimate child also gets half of the share of the legitimate child taken from the free portion. You should note that. It is taken from the free portion. The share of the legitimate child. Surviving legal spouse, 1/4 of the estate from the free portion also. Free portion, none. There's none. Because it's that. Example, the estate is 1 million. The legitimate child receives 500,000. The legitimate child receives 250,000. And the surviving legal spouse receives 250,000. Without a will, the legitimate child gets half of the estate. The legitimate child gets half of the share of a legitimate child taken from the free portion. It's also the same from the one with a will. And the surviving legal spouse gets 1/4 of the estate from the free portion. Example, if the estate is 1 million, the legitimate child receives 500k, the legitimate child receives 250k, and surviving legal spouse receives 250k. Another illustration is surviving legal spouses, legitimate ascendants, grandparents or parents, and illegitimate children. With the will, legitimate ascendants of the deceased gets half of the estate. Surviving legal spouse gets 1/8 of the estate taken from the free portion. Illegitimate children gets 1/4 of the estate, and free portion gets 1/8 of the estate. Example, if the estate is 1 million, the legitimate ascendants receive 500,000. The parents inherit if they are still alive. Otherwise, the will grant. Let me repeat that. Otherwise, the grandparents inherit with the panel side receiving 250k and the maternal side receiving 250k. The legitimate children receives 250k, and the surviving legal spouses receives 125k. The rest can be given to whomever the estate owner wishes, as stated in the will. For example, if the estate owner wishes to give the legitimate child the rest of the free portion, he can give it all, as long as it is stated in the will. Now, without a will, legitimate ascendants of the deceased gets 1/2 of the estate, with nearest ascendants inheriting. If parents are alive, this share goes to them. If grandparents are alive, the share is split between the paternal and maternal sides. Surviving legal spouses gets 1/4 of the estate, and illegitimate children gets 1/4 of the estate. You can see that there's no proportion because they've divided equally among them, because that is without the will. For example, if the estate is 1 million, the legitimate ascendants receive 500k. The parents inherit if they are still alive. Otherwise, the grandparents inherit with the paternal side receiving 250k and the maternal side receiving 250k. The legitimate children receives 250k, and the surviving legal spouse receives 250k. Moving on. Wills. This is an act in which person is entitled, subject to specific legal requirements, to exercise some influence over the distribution of his estate after his death. An act whereby a person is permitted, with the formalities prescribed by law, to control to a certain degree the disposition of this estate to take effect after his death. A document whereby a person disposes of his or her properties or estate to take effect upon his or her death. There are kinds of wills. One is the notarial, ordinary, or attested. This is a will that is one that is executed in conformity with the procedures outlined in New Civil Code, Article 804 to 808. In the absence of bad faith, forgery, or fraud, or undue and improper pressure and influence, defects and imperfections in the form of attestation or in the language used therein shall not render the will invalid if it is proved that the will is in fact executed and attested in substantial compliance with all the requirements of the law. Second kind of will is the holographic. This is a written will which must be entirely written, dated, and signed by the hand of the testator himself, subject to now added form, and may be made in or out of the country and need not be witnessed. A holographic will is a handwritten and testator signed document, and it is an alternative to a will produced by law. Some states do not recognize holographic wills. States that do permit holographic wills require the document meet specific requirements to be valid. Codicil is a supplement or addition to a will made after the executions of a will, and annexed to be taken as a part thereof, by which any disposition made in the original will is explained, added to, or altered. Probate of a will. Court procedure by which a will is proved to be valid or invalid. The proceedings in the absence of a last will and testament is called intestate proceedings. The difference between a notarial and holographic will is in form. A holographic will must be handwriting entirely, handwritten, whereas the notarial will has specific forms under the section 805 of the Civil Code that must be complied with. For example, this is the notarial will that has specific forms under the section 805 of the Civil Code that is in compliance with. And this is the example of a holographic will, which is entirely written, dated, and signed by the hand of the testator himself. It may be made in or out of the Philippines, but if a testator is in a foreign country, he is allowed under the Philippine law to make a will in any of the forms established by the law of the country in which he may be. The validity of a will which was executed in a foreign country may be established here in the Philippines. In establishing the validity of a holographic will, it shall be necessary that at least one witness who knows the handwriting and signature of the testator explicitly declare that the will and the signature are in the handwriting of the testator. If the will is contested, at least 3 of such witnesses shall be required. Please take note, the joint will, even when allowed in the foreign country where it was executed, shall not be valid in the Philippines. Moving on. Foreign of wills. This is the will of an alien who is abroad. Procedures effect in the Philippines if made with the formalities prescribed by law of the place in which he resides, or according to the formalities observed in his country, or in conformity with those which the Philippine Civil Code prescribes. Revocation of wills and testamentary dispositions. A will may be revoked by the testator at any time before his death. Any waiver or restrictions of this right is void. Modes of revoking a will. 1 is implication of law. 2. By some will, codicil, or other writing executed as provided in case of wills. 3. Burning, tearing, cancelling, or obliterating the will with the intention of revoking it by the testator himself or by some other person in his presence by his express direction. Institution of here under the Article 840. This is an act by virtue of which a testator designates in his will the person or persons who are to succeed him in his property and transmissible rights and obligation. Disinheritance. This is a testamentary disposition by which a compulsory heir is deprived of, excluded him from the inheritance to which he has right. Why this inheritance happen? There are many instances why this occurs. An instances when a child or descendant has been found guilty of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. When a child or descendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found groundless, and many more. But these are the requisites for this inheritance. 1. Effected through a valid will. 2. For a cause expressly stated by law. 3. Cause must be stated in the will itself. 4. Cause must be certain and true. 5. Unconditional. 6. Total. There's no partial disinheritance. 7. The here disinherited must be designated in such a manner that there can be no doubt as to his identity. Under the Article 850 of the Civil Code provides that the burden of proving the truth of the cause for disinheritance rests upon the other heirs of the testator. If they should deny it, the grounds or causes as defined by law shall be limited to those expressly stated by law. Article 850 also provides that no institutions of here shall be annulled when the cause is not one of those set forth in Civil Code or which is not among those listed above. Right of representation. This is the right created by fiction of law where the representative is raised to the place and degree of the person represented and acquired rights which the latter would have if he were living or could have inherited. This may arise because of death, incapacity, and disinheritance. They shall not inherit more than what the person represented would inherit. Right of representation is not available to as the compulsory heirs in case of repudiation. The one which repudiates his inheritance cannot be represented. Their own heirs inherit their own right. 2. Voluntary heirs. 3. Voluntary heirs, legatees, and devisees who predecease the testator or renounce the inheritance cannot be represented by their own heirs with respect to their supposed inheritance. Only offsprings of other or sisters, whether full or half-blood, have the right to representations provided they agree with at least one uncle or aunt. This rule only applies when the dead has no offspring. Nephews and nieces who were living when the aunt or uncle died can inherit on behalf of their deceased parents. If the nephews and nieces are illegitimate, they are barred from inheriting from their father's or mother's relatives, such as uncles and aunts or even grandparents under the Article 990 of the New Civil Code. Grandnephews and grandnieces in the collateral line do not have the right to inherit either. And that is all. Thank you for listening for my discussions about business taxes, in particular about the transfer and business taxation with special topics in Chapter 1, Succession and Transfer Taxes. And again, my name is Maurice Rivera, an accounting student, third year student at Pass College. Thank you for listening, and that is all.